Yes, Mr. Pasipanojga.
If it pleases the court, my name is Tadiwa Pasipanojga. I appear for the plaintiff. I would like to make an application for your recusal from the matter that is before you, my lady. Before I move to address what the court should apply its mind towards, could I begin by expressing that this application is not to be seen as a personal attack on you, my lady. That said, I would like to give a brief background of the facts that have culminated in the case that is before the court. The claim is that the Happy Couple Lodge discriminated against my clients. My clients are two men who were married during a holiday in South Africa and who now live together in the United Kingdom as a married couple. My clients booked a week's holiday online at the lodge, and they made this booking in their capacity as a married couple. There was no mention of couples having to be married, but there was mention that the lodge specialized in couples and no children. When my clients arrived for their holiday, they were told that they could not have a double room because they were not married. They protested and insisted that they were married chapter and verse, but they were told that they were not married in the eyes of God. They then requested for 2 single rooms. That request was then denied. They were told that contrary to the evidence that was upon the website of the lodge, that there were no rooms that were available. The only inference that we can gather from this was that the lodge did not accept homosexuals. It is a humble submission that my lady should recuse herself from hearing the matter due to bias. At law, the test for bias is a two-pronged test. The first element is an apprehension of bias must be reasonably ascertained. The second element is that the apprehension must be held by the reasonable person. A reasonable person in such a case is one who does not have an interest in the case, but one who seeks for justice to prevail. Now, having carefully considered the facts of this case, coupled with the status that my lady has in community, my clients have expressed concern that unwittingly prejudice may creep in. My lady is seen as a paragon of virtue in the local community and in particular in the local church, indeed acting as a lay preacher from time to time. But therein lies the problem. My lady, you are known to be staunchly religious. It is well known that the teachings of your church abhor homosexuality. It is seen as an offense before God. Homosexuals are not welcome in the church. Moreover, the gospel preaches that people should not live in sin. The sanctity of marriage is paramount, is one of the central tenets of the religion. My lady is a prime example of the kind of life that the church expects of its clergy, happily married with 2 children. Whilst I'm sure that whether or not my lady holds what some have characterized as extreme views, you will do everything you can do to suppress such views in dealing with any cases. However, we cannot still rule out a high risk of bias. Given the test of bias we have submitted, we have shown that there exists a reasonable apprehension of bias, and secondly, we humbly submit that this apprehension is one that will be held by the reasonable person. My client therefore seeks that you recuse yourself from hearing this matter, my lady.
Yes, Mr. Pasipanojga, it appears you've already made up your mind that I'm biased against your clients, but I will proceed to hear the other side.
If it pleases the court, I'm appearing on behalf of the defendants. I object very strenuously to this application. It is an outrage that my learned friend should seek to impugn the integrity of this court. He rightly acknowledges that my lady is a paragon of virtue. Then in the next breath suggests that you might be biased. The court should not tolerate such an affront, and it is therefore my client's submission that the court refuses this application. If it pleases the court, I'm appearing on behalf of Advertising Standards Authority, ASA, for an application for a mandamus against Potter's Plumbing Services. For one to be granted a mandamus, the following requirements must be proved. There should be a clear obligation on the part of the applicant. There must be an injury that was actually committed or reasonably apprehended, and there must be no other satisfactory remedy available to the applicant. According to ASA's Memorandum of Incorporation, it is an independent body that seeks to ensure, both in the interest of the public and in the interest of the advertising industry, that advertising in South Africa can be trusted. Its role is to regulate advertising in South Africa in a manner that ensures consistency with the principles of accountability and transparency. The company therefore provides a system of recourse for those who may be harmed or prejudiced by an advertisement, and thus protects consumers' right to access to information by ensuring that information showcased to consumers is not misleading and adheres to the Constitution's precepts of transparency and openness. My client is therefore approaching the court in the interest of the public, as well as in the interest of its members, as allowed by Section 38(1)(d) and (e) of the Constitution. My client is thus seeking an urgent prohibitory order against Porter's Plumbing Services to stop them from having their advertisement published in the Yellow Pages on Monday. The circumstances leading to the application are that, a week ago, my client received a complaint that Porter's Plumbing Services advertisement is misleading and deceptive. This assertion was made based on location, as the complainant was given the false impression by the advertisement that the plumbing services she was employing were local and that a plumber nearest to the job is allocated when the job is urgent. However, in the complainant's case, the plumber who was allocated came from the other side of town and took 2 whole hours to arrive for an urgent job. Such late arrival stands as an antithesis of the impression given by the advert, which is that a plumber is discharged from Rosebank and therefore would arrive swiftly when allocated to an urgent job. In the complainant's case, she expected the plumber to arrive within 30 minutes, and the plumber only arrived within 2 hours, and this cannot be said to adhere to the impression given by the advertisement. Furthermore, ASA's files on Porter's Plumbing Services revealed that a year ago, when Porter's Plumbing Services first started to advertise in the Yellow Pages, a separate complaint was lodged by a resident of Morningside about excessive administration fees. After the complaint was received, a letter was sent by my client, who is ASA, to Mr. Potter, who is the director of the plumbing services, requesting for him to withdraw the advertisement on the basis that it was misleading and deceptive. Subsequently, Mr. Potter informed my client that he would seek legal advice. He did not contact my client further, and his failure to do so gave my client the reasonable impression that he was not willing to adhere to ASA's code of conduct, and instead opted to continue displaying misleading information to the public. Clause 4.21 of Section 2 of the Code stipulates that advertising should not mislead consumers by means of ambiguity, confusion, exaggeration, or omission. The basic point of departure would therefore be whether a hypothetical person, reasonable person, reading the advertisement would be misled. It is my client's submission that the advertisement would mislead a reasonable person to believe that the plumbing service offered are local, as the advertisement explicitly only refers to Rosebank as its primary location. The prohibitory order is therefore the only remedy that can be made available, because Porter's Plumbing Services' refusal to adhere to ASA's request to withdraw the advertisement a year ago shows a clear refusal to not be bound by its code of conduct. This honorable court therefore possesses the required authority to prohibit the publication of the advertisement in the Yellow Pages. Doing so would protect my client, who is acting in the interest of the public, from having access to information that makes either direct or implied misleading claims and untruthful representations. It is therefore my client's submission that the Honorable Court grants the application to stop Porter's Plumbing Services from advertising in ASA's Yellow Pages.
Yes, are you done, Ms. Butler? Ms. Tinya Tsambo.
May it please the court, my name is Nyasha Gift Nyatsambo, and I appear on behalf of Porter's Plumbing Services, the defendant in this case. In this application, we vehemently oppose the granting of an order to compel my client to withdraw their adverts from appearing in the next edition of the Yellow Pages. My lady, we submit that an urgent order should not be granted in the present circumstances for the following two reasons. One, that the advert in question is not in fact misleading and or deceptive. Although we acknowledge that the applicant, ASA, as the body regulating the standards of flighted adverts, has a duty to ensure that advertisements falling within its jurisdiction adhere to a particular standard that ensures that the public are not deceived or misled, we strongly argue that the allegations that my client's flighted advert is misleading and deceptive does not seem to ring as true in the matter before this honorable court. The applicant uses the issue of location as one of the grounds for arguing that the advertisement is misleading. We, however, submit that the information on the advert in issue does not in any way give an impression nor a guarantee that a Porter's plumber is based in Rosebank. Instead, what the advert reflects is Porter's Plumbing's services commitment to addressing a plumbing problem, ASAP. This commitment can be fulfilled even if the plumber is not based in the client's area, as my client has reputably achieved for over a year. In the present circumstances, it must be highlighted that in making a request, Ms. Carmen Costa only indicated that she needed a plumber urgently and not one based in Rosebank. Being within my client's capacity, they immediately dispatched an available plumber who so happened to be from Bosman. Unfortunately, my client's services to Ms. Carmen Costa was affected by extenuating factors beyond the control of my client. Had it not been for the traffic jam, Ms. Carmen would have been speedily attended to, as is my client's forte that has seen them being voted as the best plumbing service in Gauteng. Nevertheless, it is our humble submission that this inconvenience to Ms. Carmen cannot be attributed to the information contained in my client's advertisement, and therefore the claim that it would mislead a reasonable person does not hold water. Pertaining to the question of exorbitant charges, it is alleged by the applicant that my client's advertisement is deceptive because it does not indicate that an admin fee is charged above the service charge. We strongly oppose this position as it is frivolous because the advert clearly indicates with an asterisk that an administrative fee is chargeable. My client acknowledges that it is possible that sometimes their clients in moments of stress due to the urgency of their plumbing needs may not be able to fully comprehend the clause, but it is our submission that the inclusion of the clause in small print is common practice in the plumbing and construction industry, and it is expected that clients would be well acquainted with the charge. I therefore assert, as shall be supported by our argument below, that this on its own cannot be a basis for compelling my client to urgently pull out their advert from the Yellow Pages. The second basis for our opposition is that there was no proper engagement prior to the tabling of this application. My lady, it is, even if the advertisement is established to be misleading, we strongly hold that the applicant has jumped the gun in this matter by rushing to make this application without reaching out to my client to establish an amicable position. It must be put to the attention of this honorable court that my client has always been open to engagement with the body and is willing to settle the dispute in a manner that takes into account the interests of both parties. It is therefore a surprise to my client that in spite of them having buried their hatchet with Ms. Carmen Costa, the ASA has decided to hastily institute these proceedings without extending an olive branch to my client. Surely, it is in the interests of fairness that ASA should have first sought out to my client, whom would not have hesitated to amend the advert in question before it went out to print. We thus humbly submit to this honorable court that my client would be unnecessarily inconvenienced especially when the gravity of the losses that they are to suffer should the order be granted is considered. In conclusion, if it pleases this Honourable Court, we would take this opportunity to submit a prayer to this Honourable Court that a mandamus must not be granted for the reasons laid out above. Thank you.
Yes, who appears for the applicant in this bail application?
I appear for the applicant, my lady. If it pleases the court, I am Advocate Nyasha Gift Nyatambo, and I am appearing for the applicant in this matter, Mr. Pai, who is being charged with culpable homicide and possession of an unlicensed firearm. My lady, Section 60 of the Criminal Procedure Act states that an accused is entitled to bail if a court is satisfied that the interests of justice so permit. This critical question before the Honourable Court, therefore, my lady, requires that several factors be fulfilled before bail is granted. The first factor before this court is whether there is a likelihood of the accused evading his trial. My client is a 33-year-old happily married father of 2 minor children who is well regarded in his community in Newlands, in which he has resided since birth. Mr. Pai is considered a pillar in his community where he plays an active role by not only heading the neighborhood security detail and guiding the local Boy Scout club, but he also boasts an economic presence in the community, being the owner of 3 barbershops that employ 15 local people. He owns the properties the barbershops are housed, together with a portion of his marital home and another property in Kenilworth, in which he rents out. It is therefore our humble submission that Mr. Pai has well-cultivated ties in his community, his family, and his business interests that would certainly dissuade him from absconding his trial should he be granted bail. Furthermore, even though my client is privy to the gravity of the punishment that would likely be imposed should he be convicted, we assert that the apparent weakness in the strength of the state's case gives my client ample incentive for not absconding his trial. The second factor that needs to be determined is whether the accused will pose a danger to the public if released. My lady, although we concede to the state's position with regards to the seriousness of the allegations against my client, it must be put to the attention of this honourable court that my client has no previous criminal record or a history of a violent streak. Instead, as shown by the community members' affidavits annexed to this application, my client is well regarded for his gentle and caring disposition. He in no way poses a danger to the public, nor does he inspire a risk of reoffending. The state's mere reliance on the seriousness of the offense that my client is charged with is thus baseless, and it is not supported by any concrete evidence that my client will pose a danger to the public should he be released. The third factor that the Honourable Court may need to determine is whether the accused will attempt to influence or intimidate witnesses and or to conceal evidence. My lady, in the present circumstances, there cannot be any fear of my client influencing witnesses, as there are no documented witnesses to the event. Instead, as is common cause, the state is heavily reliant on the evidence contained in my client's affidavit to ground its case against him. Regarding the possibility of concealing evidence, it should be brought to the attention of this court that my client is a law-abiding citizen who has a history of responsibility and integrity and would never attempt to conceal evidence. Even in the present matter, it must be borne in mind that it was my client who took the initiative to notify the authorities about the tragedy that befell Duduzane, his neighbor's son. My client never made an attempt to abscond or to obstruct the administration of justice, but remained firmly cooperative, even voluntarily accompanying the police to the Newlands police station for questioning. Surely, this exhibition of good conduct by my client supports our contention that there is no likelihood whatsoever of him tampering with the proper administration of justice. Finally, having outlined the above compelling reasons why bail should be granted, we acknowledge that the interests of justice demand a balance between the interests of the accused and that of the community in meeting the ends of justice. We therefore propose the following as conditions that can be attached to my client's bail. 1. Mr. Pai, who reside at number 17 Tracy Chapman Drive, Newlands, and will report weekly to a probation officer at the Newlands police station. 2. Mr. Pai will also surrender his travel documents to the probation officer as a guarantee that he would not try to abscond his trial. Accordingly, it is respectfully submitted that my client is a suitable candidate for bail, and it is my prayer that this honorable court grant bail to Mr. Pai subject to any conditions it deems necessary. Thank you.
Yes, thank you. Ms. Khalifa.
May it please the court, I appear on behalf of the state. The state opposes Mr. Pai's bail application on the basis that it is not in the interest of justice to release Mr. Pai on bail. Section 60, subsection 4B of the Criminal Procedure Act states that it is not in the interest of justice to grant bail where there is a likelihood that the accused may attempt to evade his trial if released on bail. Therefore, the question before this court is whether there is a likelihood that Mr. Pai would evade his trial should he be released on bail. The state concedes that the accused has strong family and community ties and multiple investments. However, we submit that this is not enough to show that Mr. Pai may not attempt to evade his trial. The CPA provides multiple factors that a court may take into account when determining whether bail may be refused. The first factor that this court may take into account is the seriousness and gravity of the charge on which the accused is to be tried and the strength of the case against him. Mr. Pai is charged with culpable homicide and possession of an unlicensed firearm. These two charges are two very serious crimes carrying a minimum sentence of 15 years each. We oppose the defense's claim that the prosecution's case against the accused is not strong. On the contrary, Mr. Pai has already admitted that he fired the shot which caused the death of the deceased and that the firearm which he used belonged to him and was unlicensed. The only element that needs to be proven in this respect is that of negligence, and this element can only be proven by a court of law at a trial. The second factor that a court may consider is the means and travel documents held by the accused which may enable him to evade his trial. Mr. Pai is a wealthy man, and this is evident by the multiple businesses and properties which he owns. Therefore, he has access to vast resources to enable him to leave the country speedily. Mr. Pai is also well acquainted with Malawi, as he has visited the country on many occasions and has already started a business in Malawi. Therefore, he may flee to Malawi. However, we submit that although Mr. Pai may flee to Malawi, South Africa and Malawi have an extradition order which would obligate Malawi officials to hand over Mr. Pai should he flee to Malawi. However, we submit that it may take considerable time and resources for Malawi officials to find Mr. Pai and hand him over to South Africa. Thirdly, the Act allows the court to consider any other factors. Mr. Pai is a neighbor to the deceased's family, and should he be released on bail, he will be in close proximity to the family, and therefore further traumatizing them and making their mourning process even more difficult. We therefore submit that considering the above-mentioned factors, that it is not in the interest of justice that Mr. Pai be released on bail. Thank you.